Hi. Good morning, good morning, good morning. Good morning. Come on in, guys. It is the day after the recusal. It's the day after. There's so much to talk about. So much to talk about. I'm so happy Ollie here. Happy Tuesday. Happy Tuesday. There is a lot that we are going to be going through, so I'm not even going to waste time. If you are just tuning in, if you're just waking up on this Tuesday morning, you're like, AV, it's 9:30. You're streaming again. You were just with Lee yesterday. You already broke the news. Well, there is something that I found. Because you guys know me. I like to dig. Right? I have lawyer brain. I like to dig and I like to find a few things out. Where are we right now? Well, number one, Judge Krause issued her ruling yesterday. So I'm going to go over that with you. But I was thinking this morning, I was just like, I really want to learn a little bit about the new judge. I want to learn a little bit more about her. What are her habits? How does she rule? This is going to be a new face in the YSL trial. So what's she like? So, of course, you guys know I started with doing some research on our new judge, right? And I found some things. So do me a huge favor as you come on in. Hit the like button for me. And you're going to want to watch this video towards the end because I found some pretty interesting stuff. Super, super interesting stuff. So without further delay, here's what we're going to do today. I'm going to review that order one more time for those that are just now getting up to speed with everything that is happening in the YSL trial. Judge Glanville has been officially recused from the case. He cannot handle the case anymore. Of course, he's still going to be a judge. He's going to handle other cases, but there are several issues still open right now. So we know we have a new judge. Trial is going to resume. But when it resumes, there's a few next steps that we need to all be aware of. Number one, you bet your ass, Brian Steele and others are definitely going to be filing a motion for mistrial, like immediately. As soon as she hits that gavel and she's like, let's go, there's going to be objections. There's going to be objections immediately. There are going to be motions for a mistrial right away. Like that's going to happen. So I just want y'all to be aware of that. But the other thing we're going to do is we're going to go into her bio. And I also have some new data as far as how she has ruled in the past, if this looks favorable for the judge. And I want y'all to weigh in on that as well, if it looks favorable for any of the defendants that are in this case, right? So super, super interesting stuff. Apologies, you guys know the planes. The planes are so loud. Some of y'all say you could never hear it, but I can. The other thing that I do want to mention before we get started, I'm going to come to y'all in the chat, see who we have in the building. We'll get right on into the order, and then I'm going to show you the other document that I found. It is Prime Day. And if y'all are Amazon shoppers, you might want to go and get the things that you've been eyeing for a little bit, and particularly for our creators. I have a link in the description box where I have a link to everything that I use in my studio. You guys know I'm in a temporary space for right now. All my stuff is being shipped up from Atlanta, so I will be back in the law lab, so to speak, in a few more days. But for those of you that are interested in the mics that me and Lead use, like some of the equipment that we use, I have like a whole list. You might want to check that out, especially on Prime Day. So just wanted to give you guys that quick disclaimer. All right, let's jump in and see who we have in the building. Look at EC. EC has entered the chat and she says, first, good to see you. Good morning to Sagalina. Good morning to Faison. Good morning to Eric. Good morning to Say What. Good morning to V. So many of you guys are in the building. Shout out to Tyree, who's in here. Breezy F Baby. Nurse Janice, and she knows I'm gonna ask her what time it is, so now she's including it. Nurse Janice is in the building, and it is 2:30 in the UK. Look at that. Mixed Chick Samantha, it's good to see you, Sam. Hey, Becky, good to see everyone this morning. Good to see you. Maximus says you're an hour ahead. I am sorry. It's early. Like if you're on the West Coast, it's like 6:30. I'm sorry, guys, but I needed to jump in. We have been working really hard here at Team AV7. We have to revise a whole video. Like yesterday, I made a video for you guys on YSL, sent it to the editor. He started chopping it up. Guess what happens? The freaking motion comes out, and I was like, damn it. So what is the fastest way? When something like that happens, what is the fastest way for us to do content over, right? And so I'm like, lead, we got to go live. The fastest way for us to deliver content for you guys is to live stream, but we have to revise that video. It's still very good. And if y'all were over on lead side yesterday, we had a great time. It was a hilarious stream. He got into character and started rhyming. Shout out to King Slime, YSL lead, lots of fun jokes from that stream. So we're definitely going to be chopping that up in our recap. So can't wait. It's going to be amazing. Shout out to Lady J. Shout out to Roxanne. I haven't seen you in a minute, Rox. Hope you're doing well. Shout out to Jason. Shout out to Carlos in here as well. Shout out to Blue Nitty. Good morning. Good morning. All right. As y'all are filing in, let me go ahead, capture a few supers, and then we will review our motion. Shout out to the Little Gaming Channel who sends $10. Thank you, Little Gaming Channel. He said, good morning, sunshine. Good morning to you. And it's early where you are in Cali. It is very, very early. Shout out to Dylan with $4.99. He says, keep doing your thing, girl. Thank you, Dylan. Thank you. And then shout out to Carrie. Carrie sends $1.99. Thank you so much, Carrie. All right, guys, without further delay, let us jump in and see what we are looking at. Again, we're going to go into this new judge's background. I want to tell you a little bit more about her, where she went to law school, things of the like, how long she's been on the bench, her professional experience, all of those things. And then we're going to get into some real data that shows how she's ruled in the past and what that looks like for the defendants moving forward. So we're getting into some analytics, okay? We are doing that. So I'm really, really excited to be able to nerd out and geek out over that stuff with you guys. Without further delay, why don't we do this? Let's look at the motion yesterday that was just filed. And this is coming from Judge Krause. Okay, so I'm going to go through it very quickly because this is not going to be new news to many of you, but for those that are coming up to speed, you're seeing this. So this is Judge Krause. This came out yesterday at 11:26 a.m. So it's been about 24 hours, just over 22 hours since this ruling came out. So the order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including three things. One, Diamante Kendrick's motion to recuse Chief Judge Glanville filed on June 12th. Shout out to Doug Weinstein. I sent him a message and said congratulations, and he is thrilled with this. So that's super, super awesome. Shout out to Kayla Bumpus. She also had a motion to quash the show cause order and or the recusal of Judge Glanville, right? And then three, we have Brian Steele, so defendant Jeffrey Williams' motion to disqualify and recuse Judge Glanville and all further dealings in the above referenced case and amended supplement. So those are the three things. These are the three orders that Judge Krause had to look at. So again, we know that Doug Weinstein is super pumped. Team Diamante is super pumped. And I think Doug did put out a statement that he absolutely intends to file a motion for mistrial. So know that is coming. All right. Shout out to Kayla. I'm sure she's doing her thing on YouTube. So now she is officially released from this case. She does not have to deal with, the secret meeting and all the aftermath from the secret meeting. So I'm sure she's going to be reviewing this on her channel. And then lastly, Brian Steele did put out a statement this morning, just kind of with the overall reactions. I could pull that up for you guys, but honestly, it's really short. It's like 3 sentences, and it was really just for the press and the media. Young Thug is obviously super, super happy with this outcome. But the other thing that comes along with it that Brian Steele mentioned, he's just like that they are grateful that they finally found a judge that follows the law. It was pretty interesting to see that, right? So we know that all three of these parties have been successful in this motion. So that's really good. All right, so the specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. So findings of fact. So this is what the judge had to look at, and she typed this up. This is her understanding of the facts. These recusal motions arise out of a multi-defendant prosecution bought by the Fulton County District Attorney's Office, alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 24. The motions to recuse all arise from the same set of circumstances related to the state's witness Little Woody. On June 7th, the state intended to call Little Woody to testify. Prior to his testimony, counsel for Little Woody, John Melnick, appeared and indicated in open court that Little Woody did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Little Woody into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Little Woody. Judge Glanville specifically advised Little Woody that if he invoked the Fifth Amendment and refused to testify, the state would ask for Little Woody to be held in contempt and jailed. Judge Glanville also advised that, if asked, Judge Glanville would jail Little Woody for refusing to testify. So this part is the witness coercion that we've been talking about for a little while, right? This is the witness coercion that Brian Steele and many, many, many others talked about in their motions. And the other thing with this secret meeting and this ex parte meeting, you guys know the defense counsel should have been made aware that it was taking place. And there are several other problems with it. Now, there is something else she says in here where she says that, honestly, it doesn't look like Judge Glanville did anything wrong, which, I mean, that's a whole different ballgame. That's a whole different story. Also, notice that this document is only 10 pages long. She really, really didn't spend a lot of time with it. She really didn't put in a lot of case law. It seems as if it was done really to appease the public, right? And we'll talk about that in a second, but let's keep going. After that discussion, Little Woody spoke to his attorney and then indicated that he would testify. Once called, Little Woody was asked to specify his age, and we remember that he said grown. And instead of answering, he stated, "I plead the fifth." Judge Glanville excused the jury and then advised Little Woody in open court that he was in contempt and ordered him jailed until Monday, the 10th. So basically, Little Woody spent the weekend in jail, at which time Judge Glanville told Little Woody that he would revisit his willingness to testify. Mr. Melnick spoke to Little Woody and then reiterated to the court that Little Woody still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Little Woody on Monday, June 10th at 8:30, and court was adjourned for the day. Now, Monday came around, and approximately at 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Little Woody, Kayla Bumpus. So this seemed to be the three of them and the court reporter. And I know we had some law enforcement in the room as well. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress upon Little Woody the risks of refusing to testify and allow Little Woody to ask questions before he testified. So remember we were talking about that? Like, what was the purpose of the meeting? What was the stated purpose of it? So it kind of feels like it falls under witness coercion. Why? Because we're asking you again, right? You've already invoked your Fifth Amendment privilege at this point. I plead the fifth on Friday. Now we're here on Monday, and now we're talking to you again about it. Are you sure you still want to plead the fifth? Do you want to change your mind? Do you have any questions? Interesting. Super interesting, guys. Let's go back in. Ms. Love also expressed concerns to Judge Glanville about Little Woody's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Little Woody. Little Woody was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state, who had joined the meeting. During that time, the state advised Little Woody that he could remain in custody until the conclusion of the trials of all the defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA sections 245507 with Little Woody and his rights and responsibilities after the grant of immunity. Little Woody spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Little Woody was brought out to testify, here comes the GOAT, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Little Woody and Glanville, Brian Steele in Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. He wanted the names. He wanted to know who the mole was. And that's the thing, guys. We never found out who the mole was. We never found out who the mole was. Let's keep going. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams, ultimately, Little Woody did testify on June 10th, 2024, and was later released from custody. Why is that important? She has to show that the meeting took place, but Little Woody was allowed to testify. He was able to cure being in contempt. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by Diamante Kendrick on June 12th. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the alleged improper and coercive ex parte meeting with the state. 2 days later, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, right? Remember those 3 prongs? It was supported by an affidavit and on cursory review contains assertions of facts to support the allegations of bias and impartiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, there was no actual evidence of the extent of the discussion during the in-chambers meeting. The affidavit was legally sufficient and the motion to recuse did not require another judge for consideration. That was Judge Glanville's decision on why he should not recuse himself, right? That was his reasoning behind it, was that he gave them 2 of the 3 buckets. Like, okay, these 2 buckets are fine. You got those requirements. However, when it comes to the facts, how are we going to verify these things? That's where we have a problem here. That's where the problem arose. Let's keep going. On June 14th, Kayla Bumpus then filed a motion to quash the show cause order and to recuse Judge Glanville from presiding over any contempt action against her, resulting from alleged disclosure of the ex parte meeting. On June 17th, that's when we have Brian Steele filing his motion to recuse Judge Glanville. Divorced from its hyperbole, Mr. Williams' motion to supplement also to seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Little Woody. And Judge Glanville became embroiled in controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. All right, now we're getting closer in time. On July 1st, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for the ex parte meeting. In addressing the circumstances of contempt against Brian Steele, Judge Glanville explained that the court's purpose and concern in pursuing the information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. This is actually something that I don't think Lee and I caught yesterday. There was a point where they were looking at surveillance footage because they were so concerned with who the mole was. And I remember Kayla being specifically shocked by that. Like, why are you looking at security footage? Right? And right here, it says that the reason why he was looking at security footage is because they wanted to review it for the timeline and security pieces. Okay, that's why we did it. Interesting. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the secret meeting. Judge Glanville also questioned the defendant's right to be present at the ex parte meeting because the issue under the discussion was between the state and a witness who was represented by counsel. This is important too, this whole section right here. Brian Steele did want let's go back in time. Brian Steele did want Young Thug to be able to go to the in-camera meeting to check out the transcript. That's when, he didn't want to make the full thing available. But, that issue, and you guys were asking about what moot means, that issue becomes moot. Basically, moot means it's irrelevant anymore based upon other decisions that were made prior to it. So we'll talk about that more in a second. But even an issue like that would become moot at a certain point, right? But I do want to point this out because a defendant does have a right to, their accuser and things like that. What she's saying here is Judge Glanville's argument, right, was that it was a discussion between the state and the witness. And it was really about his representation of counsel. You guys remember that Thursday, we were going back and forth, or they were going back and forth with Little Woody, because that's when Melnick was like, hey, I'm his lawyer. You need to come to me with these things instead of talking to him unrepresented and directly. Now, then we have the issue of the stand-in as well. So the entire secret meeting, what they are alleging is about Little Woody's representation and his willingness to testify, and validating if he was still going to clear or cure his contempt by taking the stand. I mean, it's coercive in my opinion, but that's really why that little section is important there. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. So what the judge did is she had to give you guys background. Here is how, play by play, date by date, what happened, how it happened, and how we got here, right? Now she's going to tell us a little bit more about her decision. Now we are on page 6. So as you can see, a majority of this document, 60% of this document, is just the facts. So her argument is rather short. It's very short. So let's come here. It says motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion, so that's bucket 1, supported by an affidavit clearly stating the facts, right? And reasons for the belief that the bias or prejudice exists. That's bucket 2. The affidavit must be definite and specific and describe bare conclusions and opinions are not legally sufficient to support the motion to further proceedings. Once such motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and the legal sufficiency of the affidavit and the facts within that affidavit. Those are your 3 buckets: the timeliness, the sufficiency, and the alleged facts. If all 3 criteria are met, the motion is timely, right? Bucket 1, supported by an affidavit, bucket 2, and the facts alleged might warrant recusal. Another judge shall be assigned to hear the motion to recuse, right? So remember, Glanville in the moment said 2 of these buckets are good. The third one is not. The one that he thought was not good was the one regarding the facts. Okay, so bucket number 3. When considering a motion to recuse, the assigned judge should be guided by Rule 211 and the revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in a proceeding in which their impartiality might reasonably be questioned. The standard is objective from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or other interested parties. If a motion to recuse satisfies the 3 buckets, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. That comes from a 2015 George case. A judge cannot become actively involved in presenting evidence or argument against a motion seeking recusal without the defense itself becoming biased for recusal. All right, now she's quoting a 1987 case. All right, so she just used about 3 cases there to support that argument. Now, this is where the decision comes in. And look, this decision, guys, is 1, 2, 3, 4 paragraphs long. And it starts on page 9. Interesting, right? Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the 3rd criteria was satisfied. That recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. So right there, paragraph 1, she actually is telling us that Judge Glanville was wrong. Right there, right? And it's really this, it's this sentence right here where she says, in transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the 3rd criteria was satisfied, that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, he was required to refer the motion for reassignment and was prohibited from opposing the motion. So that is interesting, you know, a little bit of a win, right? Let's keep going. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. So she agrees with him on that part. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or substance discussed was inherently improper. This is where a lot of people are having a problem. That sentence right there. However, in this order denying defendant Kendron's motion and the process of making his record on July 1st, Judge Glanville added facts, provided context. He questioned the veracity of the allegations and otherwise explained his decisions and actions and argued why these actions were proper. That whole section right there is she's giving more context on why that was wrong, right? It should have been transferred. It should have stopped. However, this is what you did, Judge Glanville. You added facts. You provided context. You questioned the veracity of the allegations, and you explained your decisions and actions. Then you argued why those actions were proper. So that's where he was wrong. You know, we understand the whole thing about the buckets, but at the end of the day, it should have been transferred once we got to bucket number 3, and it didn't. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. Yeah, what did Brian Steele say a few times? It appeared as if he was helping out the prosecution. It looked like that. Let's keep going. In presenting his record as the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal. This court has no doubt that Judge Glanville can and would continue to preside fairly over this matter if the recusal motions were denied. I want to look at that footnote. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. There's 2 footnotes we're going to look at. But that is interesting, guys. She's telling us right there, she's going to the court of public opinion. What just happened last week with Baldwin? There was Brady evidence discussed in that particular case, and his whole thing got, it got taken care of right then and there. So we know, and this is around the same time that this judge had to make a decision on this case. She knows the world's watching. And, a lot of these judges are going to be up for re-election soon. A ton of them. So these decisions really matter when it comes to the court of public opinion, when it comes to you guys, when you guys actively get out there and vote, when you vote for local, judges. People don't forget how you rule. Data doesn't forget how you rule, and you guys you're gonna love what I'm gonna show you. It's gonna be amazing. I can't wait. But let's go back to this and see how she talks about this further in footnotes 8 and 9. So footnote 8 is a case from 2015. It says a judge who actively resists recusal may be fully capable of even-handedly presiding if the motion is denied. And then she cites another case for footnote 9. So those are just 2 supporting cases. So her decision is a page and a half long. And here's what it says. Based on the foregoing, this court hereby orders as follows. 1, defendant Diamante Kendrick's motion to recuse Chief Judge Oral Glanville is granted. 2, Kayla's motion to quash to show cause order and to recuse Judge Glanville is denied as moot. And again, this is what I meant, guys, because it's no longer relevant anymore. Moot means not relevant. If you want the legal, let me give you the legal definition according to Blacks. Blacks then defines moot as hypothetical or academic, and courts may have used it that way. One court holding that a case is moot when the issues presented are no longer alive or the parties lack a legally cognizable interest in the outcome of the lawsuit. So just look at it like this. Kayla's motion is no longer alive. So that's what moot means. I did see a lot of you guys ask questions about that yesterday. 3, defendant Jeffrey Williams' motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case as amended and supplemented is granted. So huge win for Diamante, huge win for Jeffrey Williams. Great job to Doug Weinstein and great job to Brian Steele. This is a huge win for them and their clients. So we know that they are absolutely going to be filing a motion for a mistrial as soon as we get back in court. Number 4, the court shall reassign this case using the court's case assignment procedures. It is so ordered this 15th day of July, Rachel Krause. So that is your motion, guys, from yesterday. That is your motion. And where does that leave us? That leaves us with our new judge. And that's what the focus of this stream is going to be on. We're going to learn a little bit about Judge Ingram. She's going to be presiding over this. We're going to learn about her history. We're going to learn about her ruling history as well. How does she typically rule? So I have a fun little data experiment for you guys. I cannot wait. But before we do that, let me come to y'all in the chat. What do y'all think? What do you guys think? Is this a huge win? Put a 1 in the chat if you think this is a win. And put a 2 in the chat if you're like, is it still a win if this case is still happening? Should it just be dismissed? There's a process to that, and we'll go through it. Let's see who we have. Shout out to Erie. Thank you so much, Erie, for the $9.99 super. Erie says, good morning, AV. Thank you for your continuous hard work and dedication to keeping us informed. We love you. I love you guys back. And again, I try to make sure that this content is engaging. It is useful, that you're learning something about the law rather than just watching it on court TV. You're doing this in a community space, and you're also doing this in a way where we're explaining it to you. When you're getting commentary from attorneys, like we're explaining stuff, you're learning how stuff works, right? And even for me, I'll be honest, guys, I'm trying to take tomorrow off because I have a practice test at 6 that I am not very confident in. So I need to take tomorrow off. So I wanted to pop on here real quick and do this for y'all, because I know we're going to get back to court soon. But our new judge here, she's going to need time to get back up to speed. Are we going to pick up where we left off? That's an excellent question, because maybe she is going to exercise and listen to what motions to for a mistrial are going to happen. Maybe she's going to be friendly to the defendants. We don't know. This case could actually go away very soon, sooner than we thought. And you guys know Adrian Love and the prosecution team does not want that to happen. So that's why when I check out this data with you, is going to be important. We are going to make some educated predictions here. So thank you so much, Erie. I'm really looking forward to showing you guys that. Shout out to D with 199. He says, go AV. Thank you, D. Good to see you this morning. Shout out to Hannibal the Conqueror, who has been a member for a month. Hannibal says, y'all watching but not liking. Get your likes up. Listen, if y'all want to look at this data, hit that like button for me. I'm telling you. Like, no one else on YouTube is going to show you this data. I mean, they might show it to you after me, but like literally, I went into the depths of legal research and I was like, who is this lady? Where can I find more about her? I went into like deep dive, 6 a.m. I was like, I need to find this for my people. So if y'all could give me a like, at least for the effort, that would be huge. Thank you guys so much for that. And thank you, Hannibal, for that comment. Shout out to Maricela, I hope I'm saying your name right, with the 199. Thank you so much, Maricela. Really appreciate that one. And look who we have in the building. Guys, Ollie the Macabre. Ollie's in the building. Ollie, thank you so much. He has gifted you guys 20 AV to the 7th Power memberships. That means 20 of you guys are going to have access to this community for free for 30 days. In fact, yesterday, I put a post up for members only. And I'm like, hey guys, going live with Leave in like 30 minutes. So you get a preview of our schedule. You get a preview of some of the content we're working on. You get a preview of some of this deep thinking content. Like sometimes when I get stuff, I will ask my members for kind of advice on the content that you want to see, things that we're missing, things that we could do better. I really look at my members as shareholders in this channel, Ollie being one of them, and Ollie generous enough to take care of you guys as well. So thank you so much, Ollie. I really appreciate you. And welcome to all the people that got gifted that membership. If you are one of those people, please say thank you to Ollie in the chat. He doesn't have to do it super generous. Ollie is the man. And look at that. Ollie has just become y'all's stream sponsor with $100 super chat. Ollie, thank you so much. He says, just showing the support and love. Thank you, Ollie. And you guys know Ollie is newer to this community, but he supports me and Lead so generously. And with that being said, I think now we need to dive into the data. Ollie's like, let's go. But let me put you in the banner, Ollie. Thanks again for your generosity. Very, very sweet of you. If y'all could type Ollie in the chat right now, that would be fantastic. Ollie, they're giving you the macaw emoji all the time. So it's good. It's good to see that. Let me put Ollie the macaw as the stream sponsor. Let me make sure I spell macaw right. Is your stream. Okay. Thank you, Ollie. And thank you guys for shouting Ollie out. I'm going to catch some of the other cash apps and supers in a moment. But before we do, here we go, guys. We're going to look at something special. I got this report this morning. And let me see, share screen. I'm going to have to pull it up first. But this is about a 6-page report. And what it's going to do is give us some insights to Judge Ingram. I'm going to read you her bio. And we're going to look at what her ruling history has been like. Here we go. Perfect. Here it is. We have her ruling history. We have how she compares to other judges in the state of Georgia. We also have data on how she's ruled on motions in the past. All of that is really cool. I was like baffled that I found this morning. I was so excited that I found it this morning. I was like pumped. I could not wait to show you guys this. This is not usually available, but here's the thing. I think with AI and technology, we can now get a better understanding and use this type of data in the future to see, hey, how do, this is actually going to help attorneys game plan cases, right? Like when you look at the ruling history of a judge. Anywho, let's go back up here because I want to make sure we can show you guys her bio. I'll read you guys a little bit about her. We'll get to know her a little bit, and then we will start looking at her ruling history. So starting here, and it is a little bit small on the screen. Let me see if I could zoom in a little bit more so y'all can follow along. Probably not. It's so weird that they do that. Thank you, Apple. You're not making this easy. Anywho, let's just go. So Honorable Shakura Ingram is a judge for the Fulton County Superior Court, 5th Judicial Administration in Georgia. She was appointed to the bench by former Governor Nathan Deal on July 9th of 2018. So she's been presiding for a few years now to fill a vacancy created by the resignation of Honorable Alfred Dempsey. Do you guys remember Alfred Dempsey? We were watching, I think it was 2 weeks ago. Some of you guys were watching the proceedings with me, and he was, it was like a ton of the severed defendants looking at plea deals. And, you know, he was the older gentleman that had went to Harvard, but he was like playing no games, like no nonsense judge. That's who Judge Dempsey is. So she actually took over his seat. Prior to her appointment, Ingram sat as a judge for the Fulton County Magistrate Court since 2015. She received a bachelor's from Clark. Okay, don't do that. She received a BA from Clark University, Atlanta. She went on to complete her JD at the Georgia State University College of Law. Over the course of her legal career, stop doing that. Ingram also practiced as a senior associate at the Thomas Kennedy Sampson and Tompkins LLP. So that's the law firm she worked for, as a senior assistant district attorney with the Fulton County District Attorney's Office. So look at that. She used to be a prosecutor and an assistant solicitor for the City Court of Atlanta. Her memberships have included the Bluckley Inn of Courts and the Atlanta Bar Association, the Gate City Bar Association, and she was a past president of the Gate City Bar Association. That's pretty cool. Georgia Association of Black Women Attorneys, the Gate City Bar Foundation, and the Georgia Association for Women Attorneys. In addition, Ingram sat as a member of the State Bar. Oh, this is cool. She sat as a member of the State Bar of Georgia's Committee on Professionalism. That's good. The Atlanta Judicial Commission and the Atlanta Board of Ethics. She's the board chair. Oh, that's good. And the Atlanta Bar Association's Women in the Profession section, past board member. From a civic standpoint, she was involved with the Delta Sigma Theta sorority. Okay, shout out to the sorors. The Lynx in Buckhead. It's My Birthday Atlanta, Inc., the author Blank Family Youth Center. So she's involved with the YMCA, was a past board member there, and the Enchanted Closet, she was a past board member there. So she's really active in the community. She's a graduate of Leadership Atlanta. Ingram and her husband, Marlon, they live in Atlanta with their 2 kids. All right. So we know that she has a lot of experience, is super, super involved in the community. Involved in a lot of associations, but when it comes to judicial ethics, this is good. I do think that she's going to she's going to be by the book. So that's excellent. That's really good news. All right. So there's a few articles about her, but I want to bring us over here. Let's start to look at some data to see how she might rule. Is she going to be pro-defendant? Is she going to be pro-prosecution? Is she going to be balanced in the middle? So let's look at active cases first. This is important because now it explains why this case was assigned to her, right? So active cases, she has 133, right? This is in Fulton County versus other judges. So where does she fall on the spectrum compared to other judges? She has a pretty low caseload right now compared to other judges. Look, it goes up to 551. So that's an interesting data point. Why? Because we know that the YSL case is going to take a lot of resources. It's going to take a lot of time. So when it came to the decision for them to transfer it to another judge, so taking it away from Glanville and putting it somewhere else, you need to make sure that the incoming judge has a lower caseload. So that was actually telling to me when I was looking at this dashboard this morning, right? So she has a low case count compared to other judges. Now, the other thing that we see on the right-hand side of the screen, we see the average case length. So usually the cases on average, Like, let's look at the active cases, or in the past, she has 321 days for average case length. So that's good. We see that in green. Ingram hears cases 26% faster than the county average of 439 days. So look at this. She's on the lower end of the spectrum. Is that a good thing? It could be. It could be. She hears cases faster. She's going to probably move this YSL case along. It was moving very, very slowly. So it looks like we might have the benefit of some speed here with having her assigned to the case. Now, on the bottom, you see this is a comparison of her versus other judges in the state. So the blue bars on the top is just her versus other judges in Fulton County. So blue is in Fulton County, and this purple on the bottom is the state of Georgia and how she stacks up on both of those data points there. Okay, so they're relatively the same. You know, her duration time compared to those in the state of Georgia, she is pretty fast. So that's good news. And then down here, as far as her active cases, yeah, she doesn't have many. She doesn't have many compared to other judges in the state of Georgia. What is the top number for cases in the state of Georgia? 1580. That's a busy judge. Those are busy judges. Those are super busy judges. All right, let's scroll down and look at some more data. Now, this is where it gets interesting. We're not going to look at the right-hand side because they don't have enough data to give us information on that. But this one is interesting right here. What is her motion grant rate? Ingram's grant rate, this is like, you know, if she grants a motion, so kind of like what we just saw, or if she denies a motion. If she grants motions, she does it at a rate of 53%. Okay, so her grant rate is 1.83 lower than the average county grant rate of 54%. It's slightly lower, but if you look at all the Fulton County judges, she is in the middle at the 53%. So this also could be a good thing. It could also be a good thing. So we're going to see how that data point is going to play out. How is she compared to other judges in the state of Georgia? 53%, right? She gonna grant it? Judges that are very pro granting motions are gonna fall closer to the 60%, right? I mean, you can't grant every single motion that comes in front of you too. So you're not gonna see anything with 100%, but those that are a little bit more favorable, like the good judges that will hear you out, that will grant your motion, they land at 60%. She's at 53. It's not far away, but that is something to consider. It seems like she's relatively balanced in the decision-making process. So that's really cool to look at too. Now, I thought this was cool too. What practice areas does she have experience in? Well, we know that she's a former prosecutor, so we know she has experience in criminal, but what sort of cases has she seen in the past? A majority of them end up in commercial, which is business, right? Commercial cases, 48%. Torts are, it's another word in the law for personal injury. So 26% personal injury. We see a little bit of experience with real property. So this is like real estate, housing, things like that. Appeals at 3%, tiny bit of family law, tiny bit of tax. Everything else is like super, super tiny. So we're not going to cover that part too much. But interesting. You can really learn a lot about judges. Now, remember we were talking about the grant rate? Now, here's where the plot thickens. Her grant rate is 18% lower than the county's average of 20%. Now let's look at her, which is this first graph. In the middle, we have Fulton County, and on the right, we have the state of Georgia. Now, when she grants motions, you see this green line, but here's where it gets scary. Look at the one in the middle, the red one. Motions denied, 83%. So this is interesting. And let me break this down. The motion type is motion for reconsidering or rehearing. Okay, so these are motion analytics, but now we're breaking down the type of motions. So how does this play out? What is the motion type? Motion for reconsideration or rehearing. So that is for her to reconsider something or rehear something. When it comes to those type of motions, it is very likely she's going to say no, because we see 83%. Now, it says lower, right? Because let's look at this. What do average judges in Fulton County land at? If they deny something, they land at 77% of this type of motion. What about the state of Georgia? Usually she's more in line with the state of Georgia at 81% denials. Fulton County itself has a 20% grant rate when it comes to this type of motion. So a little bit of interesting discussion, thought experiment that I wanted to show you guys. These are typically filed by defendants. Her grant rate is 62% lower when the defendant is the moving party. Interesting. Look at Fulton County, which has the bigger line, and then you see Georgia. She's on the outside. So Fulton County typically will probably grant these more, and they're a little defendant friendly, right? But interesting. We didn't see it for filed by the plaintiff, and that's likely because they just don't have the data, the source that I got this from. All right, let's go in a little bit more. So now we are looking at a different type of motion. How is she with motions for summary judgments? Those are usually filed at the beginning of cases. She is pretty friendly with this sort of thing. Her grant rate is 23% higher with this type of motion than the county's average of 48%. So she's looking good here. So that means if somebody wanted to file a motion for a summary judgment, they're basically saying there's not enough facts sufficient for us to move on with this case. She's actually pretty good with granting those. So if we can predict or see a motion for mistrial, she might actually hear these attorneys out. Not saying that she won't, she has to, right? But she might actually be pretty open to the idea. Fulton County usually is at 44% with these sort of things, and then the state of Georgia is at 42% with these sort of things. So she is actually higher than both the county average and the state average. So this is pretty good. And usually these are filed by the defendant. So look at that. It's 16% higher when the defendant is the moving party. So when a defendant files a motion for summary judgment, there is a likelihood that she might grant it based on these numbers. So very, very interesting. Look at her here, 45% defendant friendly with these. Fulton County average is 38%, state average is 39%. So that's actually a good thing for Thug. Let's keep going. This I don't think is relevant to us, but how has she done with motions for temporary restraining orders? 90%. 90%. Her grant rate with these type of motions is 7% higher than the county's average of 83%. She protects people. You could see that without a doubt. 90% is beautiful. But, it depends. It depends on what the situation is. But when it comes to restraining orders, at least we have the raw number of 90%. Okay. Fulton County average is 80%. And the state average is 85%. Sorry, I'll give you the exact number, 83% for Fulton County and 85% for the state of Georgia. These are when they're filed by the plaintiff. So when people are looking for some safety, she's 0.52 higher when the plaintiff is the moving party. The defendant's not going to file that. So that's why you're seeing data on the left-hand side of your screen instead of the right-hand side of your screen. All right, let's go to the next one. Motion to be relieved or withdraw as counsel. What type of motion is this? This is the motion that Kayla needed. This is what Kayla needed. This is when Woody was like, you fired. And it is likely that Judge Ingram would have granted that. Okay. She would have not kept Kayla around. She would have let her go back to Houston. She would have not held this woman in court. So I think in retrospect, this is a little funny looking at this. She has 2.4% higher than the county's average of 87%. So look at that. 90% she grants these 90% of the time, right? So if somebody fires their lawyer, we would go from there. Next, we have Fulton County's average at 87%. We have Georgia's average of 88%, right? So she's much higher than these two on the side here. And look, when we get that filed by the defendant, it's 5% higher when the defendant is a moving party. So look at that. If little Woody was in front of her and said, she fired, I want to relieve her from this case, it is likely that she would have granted that motion. So interesting. Okay, this next type of motion, and this is where the plot thickens, is this one. How does she do with motions to dismiss? She's 22% higher than the county's average rate of 80%. So where does she fall? If someone wants to file a motion to dismiss, she falls at 81% granted, right? The Fulton County average is 80%, and the state of Georgia is 81%. So she's just, she's slightly on par with everyone. But let's see what the numbers look like for defendants. So for defendants, the grant rate is 22% lower when the defendant is the moving party. You see this line on the outside? We're going to see how she does with that. And guys, that concludes this report. I hope you enjoyed geeking out with me over this, but I was so kind of like intrigued by who she was. What are her stats like? You guys see how like attorneys can use this to kind of game plan things? And as you're thinking about filing your motions for a mistrial or your motions to dismiss, you want to see how a judge typically rules. These are going to be super, super useful reports to attorneys out there. And, I know there's a lot of legal people that watch me. Man, check out this tool. I'm not even going to do an ad read for them, but I should. Wasn't that cool, guys? All right, let me come to y'all in the chat. Let's review a few supers. And again, this is a quick power hour, so I'm going to be out and hit the books and finish all my YouTube stuff today, so y'all have content for the week, but your girl definitely needs to hit the book. So let's see who we have in the building. Again, Ollie is your stream sponsor. Ollie, thank you so much for sending in that super chat. And thank you guys for shouting Ollie out. Shout out to Cam with the $20. Cam says, judge copped out on the merits of motions, cleared the state in Glanville of his conduct. She had a decision she had to come to, and she used the rule of procedure. She should have taken the assertions as true, bound by law and rule. I think that's a good point, Cam. I think it's a very, very good point. I mean, I was pretty surprised to see how short this decision was. But I mean, really, she had one job. Her job was to decide if Glanville should be removed. And she did it. She did it. And when was that? When did we get the state's response? We got the state's response last Wednesday. So if we think about business days, she was pretty quick with this. She made her decision in 3 business days. And if it was filed yesterday, she probably had that decision done by Friday. So it was a quick in and out, super, super quick in and out. So thank you so much for the super, Cam. Really appreciate you. Shout out to Relationship Talk with G's podcast with the 199. Thank you so much. He says, therefore, there it is. Therefore, YSL Young Slime lead. Yeah, listen, lead was on one. So y'all see my Instagram? There have been, over the years, there have been times where he just breaks out in freestyle. Like it happens. There's probably one other time where he was, I don't know if y'all, I took it down because, we was talking about Diddy and I didn't want to implicate lead with Diddy, but there was another Diddy stream that we did and he just started breaking out into song. I was like, it's early, it's 10 a.m. on my end, but you get lead energized, like you'll see stuff like that. Yesterday's stream was hilarious. If you want a little synopsis of that, definitely check out my Instagram. I put a clip up and we will absolutely be putting that in our recap this week before we go back to court. So thank you so much for the super. Let's go to Raphael the Moore with $2. Says AV went into the deep red YSLC with research. I did. I was like, I want to know about her, but I want to see how fair she's going to be, how impartial she's going to be. This trial has been a shit show so far. I want to also see how effective she's going to be. Are we going to waste time with certain things? Are we going to have the same court reporter? I do know that she does have other staff that work for her. So we may see some new faces in the courtroom. But yeah, I was like, I was in there. Shout out to Maria with the $19.99. Thank you so much, Maria. She says, AV, you are doing a great job with your investigations. Listen, I do it because I care about you guys. And I know that y'all would like this sort of content. And like it helps to be different from other people. Like I can't even tell you how many people covered this yesterday, but I don't think people are going to look at it from a lens of thoughtful research. That's what I like to do. And it makes it fun. You guys saw Doug Weinstein here, and he's just like, he like complimented me. He's like, I really like how you educate your folks at the same time. So it gives you variety, because you have a choice of any channel but to go to. But if you come here, just know you're going to get a little bit of extra. Can I get a like for that research, guys? Can I get a like? That was good. Shout out to Full Drinking and Half Thinking. He gave out 10 AV memberships. Full Drinking, Half Thinking, thank you so much. And guys, if you received a membership from him, please tell him thank you. Does not have to do that. Again, I treat my members like shareholders on this channel. So I may poll you from time to time. So if you have that for 30 days, you're getting it from Full Drinking and Half Thinking. He does not have to do that. And look at him. He hits me with a $20 super after that. No comment, no question, pure love of the game. Thank you so much. I appreciate you, Full Drinking and Half Thinking. Thank you so much for investing in this community and giving more people an opportunity. It's very, very cool of you. Very, very cool of you. Thanks again. Shout out to Miss Crow T-Shetty with the $20. She says, for my girl, AV. Hi, Chad. Hey, Miss Crow T-Shetty. Hope you are having a great Tuesday. Thank you so much for the love. One of my longest supporters. She's been with me for a really, really long time. I'm so happy to see you today. Thank you so much, sis. And then look who we have. This is a new face, a new name. With $20. This is Mike in Tennessee. Hey, Mike. Mike says the channel rebrand is underway. I just wanted you to know who this is and to tell you thanks so much for the advice. Yeah, guys, look at Mike and 10. This makes me happy. We were talking a little bit about like people judging me for doing consultations because my channel is too small, right? Even though I advise on a channel that has 1.7 million and the other has 700,000, whatever, none of those matter. One of my favorite things to do is consultations because I can help creators grow. But one of my favorite type of consultations to do, and I just did one yesterday, is law school consultations. I like helping people make informed decisions. And when I was coming up in law school, when I was applying, I wish I had a place to go where I can just ask somebody for a few bucks, like what law school is like. You know, so consults are very important to me. If you guys are interested in them, there is a link in the description box. Mike is someone I've met with, and as you can see, he's already making significant changes in his channel. And for my creators out there, remember, it's Amazon Prime Day. I also have a link of equipment that you could check out, and you might be able to get that stuff on sale. So look at it, and congratulations, Mike, on 10 in 10. I can see the stuff going on right now, and it looks fantastic. You're doing a great job, and you know I'm cheering you on from the sides. Thank you, Mike. Thank you. Shout out to Chestnut Checkers, became a member. I like that name. I really like that name. Welcome to the community. You are going to love it here. Shout out to Rebecca, who also became a member. Welcome, Rebecca. You're going to love it. You are going to love it. Shout out to D with $5. D says, it will be interesting to see how the state operates with this new judge. Will they still try their shenanigans? Well, I do think that this is going to be interesting, guys, and not making anything about gender. But how is DA Love and Simone, because it's likely that they know this judge, right? Why do they know her? Because this judge used to be a former prosecutor. So they know each other. Are they going to try her on the bench? I don't think they can. So the dynamics of this courtroom are going to be very, very different. Do we pick up where we left off? Because where we left off was Little Woody testifying. When we resume, are we going to continue with that? Because I'm telling you guys right now, as soon as we get back in that courtroom, I can see Doug standing up, I can see Brian standing up, and I can see them saying, before we begin, Your Honor, I'd like to file a motion for a mistrial. That's coming. So that's going to be the first open issue that we have. And that's going to be the first open issue that this judge needs to rule upon, right? She might say denied because as a former prosecutor herself, she sees the great investment that the prosecution team has put into this. Maybe not well, they're not doing the best job. But with a charge like this, RICO charges, huge RICO charges, 6 defendants, all this time, all this taxpayer money, the time of the people that have been sitting on the jury, spinning around in the chair for months, 10 months just to select a jury. Lead and I have been covering this for 2 years. I don't know if she's going to grant it, but that's why I wanted to pull the stats and walk you guys through it and see what her grant rate looks like. Is she going to grant this? What do y'all think? Let me know. Let's go to the chat. Do you guys think that she's going to grant a motion for mistrial? Put a 1 in the chat if you think that she's going to grant a motion for mistrial. Put a 2 in the chat if you think that she will deny a motion for mistrial. What do you think? I'm really curious. I mean, based on those numbers, would she? Oh, okay, here y'all come. I see some 2s. I see some 1s. It's kind of a mixed bag. It's a little bit of a mixed bag, guys. Yeah, I could just see Brian. I could just see Brian coming up. You know, this is good. We're going to have some bets. The 1s and 2s. We're going to have this bet. I'm telling you, it's going to happen this week. Once we get back into the courtroom, we already see it. Brian Steele stands up. Your Honor, I'd like to file a motion for a mistrial. Maybe Sharp stands up. Your Honor, on behalf of Shannon Stillwell, I'd like to file a motion for a mistrial. They're going to haul little Woody back in court. He's going to be sitting on that stand, getting ready to testify. We're going to see which one of you guys or which group is right, the 1s or the 2s. Is she going to grant the motion? Is she going to let it? Or are we going back to court? And the dynamics are going to be super, super different. They're going to be super, super different. Lady J says, how soon do you think they'll get back into court? We'll see. She has to get up to speed. I mean, you know, I showed you guys her caseload. It is relatively light compared to the state average. So she might actually be in the process of doing that right now. I checked 11 Alive and all these other in the news outlets. Hopefully this week, Lady J, because you know she's also got to look at where we are in the case. You know, all the open matters. She's catching up on everything. You know, we're paused at the point where does Little Woody come back? And remember what was happening, guys, before Little Woody came back. Little Woody was being so combative that Simone had to now start using like jail phone calls. She now had to start using videos with terrible audio. I hope they fix that, you know, but that's where we were. So let's say she hypothetically lets it rock and brings us back to where we were. Let's say she denies the motion. Now, is she gonna put fire under Little Woody and say, dude, start answering questions? That's what we need to see. That's what we need to see. Because remember, Glanville did not force Little Woody to answer those questions. Why? Because I think that it was already tough. It was already tough to get him to cooperate. He's had some time. He's had a vacation. He's been in the pool. He was on a dating show 2 days ago. Did y'all see that? Oh my God, that man is funny. He's been all over the place. So now that Little Woody is resuming, is she going to force this man to testify correctly? I am excited to see a new judge on this case, to be honest. So we have a few things that are coming. We have the potential, we know that the motions for mistrial are coming, and we can predict what's going to happen with that. It's either going to be denied or it's going to be granted. And then if she denies it and we go back to court, then Little Woody's back up there. That's what we're going to be. Are y'all excited? Are y'all excited? I mean, I kind of missed it a little bit. I missed trial streaming. It's fun. It's fun. Let me come to a few of you guys with super. Shout out to Army Nurse with $5. Thank you so much. She says, AV, if Little Woody asked the new judge to overturn his immunity, state, can she do it? Would she do it? Well, the state grants the immunity, so she can't do it. They have already given it. They've already given it to him, so he has the immunity. She cannot reverse that. Fonnie Willis herself thinks that Little Woody is he's really important to the case. That and Lead and I talked about this a lot yesterday. We're talking about the McDonald's shooting. Without Little Woody's testimony, without all that talking, does their case fall apart? What other evidence do they have? In a trial, guys, you have two sides of the house. You have the defense team and the prosecution's team. Now, the prosecution's team, and you'll hear us say this, they have a certain amount of time to present their case. They're almost done. They're almost done. So if we resume, and they said that they'll be done by August. August is like 3-4 weeks from now. So what other witnesses do you have? What other hard evidence do you have to pull King Slime, to hold him responsible for these crimes? What other evidence do y'all have to prove that whoever pulled the trigger, right? What other forensics do you have? We need to see that. What evidence do you have that this is a RICO conspiracy? Can we see that? So this is going to be an interesting case to follow, guys. We ain't going nowhere. This is like the trial of the summer. So we're going to keep a close eye on it. It has been a super busy weekend. Like, you know, it's nice to come back to this YSL case, because what did we see? We were covering the YSL case. Then we shifted to Alec Baldwin. Then Trump got shot. All this stuff has been happening, and that's just been in the last 4 or 5 days. I'm tired. Are y'all tired? The news is tiring. It's tiring, but I think it will be nice to go back to this case and start moving forward, right? So hopefully that answers your question, Army nurse. They cannot overturn the immunity. And at this point, they need him. They need his testimony for this case. He is such an integral part of them potentially winning this case. So thank you so much, Army nurse. An excellent question. Shout out to, I don't know how to say this. I'm just going to call you Ra with 199. Thank you, Ra. Ra says, just for the love of AV. Thank you so much, Ra. I appreciate you. I appreciate the super chat. That's very sweet of you. Also, shout out to Jason with 199 with a super sticker. Thank you so much, Jason. And I hope you guys really enjoyed that data piece. Let me come to my Cash Apps and then I will duck out of here. Shout out to Casual Economist, who provides a $5 Cash App. He says, you are streaming too early. Well, listen, sir, watch it on replay. The girls got stuff to do. There's a test tomorrow. So I need to make sure that I'm ready for that, and definitely want to take tomorrow off. The only time I will stream, guys, Lead and I are still game planning this. If the trial turns back on tomorrow, of course, we will do that. But you know how like usually like we'll take breaks throughout the day. I might duck out to study for a little bit, get to my class, and then he'll hold it down. So we're working through that schedule, but just know as soon as the feed comes on, you're going to see one of us covering this. But yeah, you better get used to getting up early again, because when the trial resumes, we usually get up around 9 or 10, like as if we're going to court to watch it. So that's what's happening. But thank you so much, Casual. That's all I have on the Cash App side. Coming back over here, shout out to Wheezy Got Money with 199. Thank you so much for the super sticker. I appreciate you. And then look at Rebecca across the pond with 10 Eurobucks. Pounds or Eurobucks? I always get confused with the symbols. But thank you so much, Rebecca. Very sweet of you. No comment, no question. Pure love of the game. Hope you are enjoying your day, Rebecca. Thank you for that one. And then shout out to Mars with $2, who says Kobe Bryant's dad died. Really? At 69? Let's look at that. Yeah, did that happen today? Yeah, you're right. TMZ, Joe Bryant, Kobe's dad, dead at 69, reported 16 minutes ago. Inquirer reported at 56 minutes ago. Yeah, and this is 4 years after Kobe. Wow, we lost Kobe 4 years ago, guys. Can y'all believe that? He looks just like Kobe, or Kobe looks just like him. He had a stroke. Looks like he had a stroke this morning. That's so sad. I'm so sorry to hear that. That's terrible. But thank you so much, Mars, for keeping us informed on the news. Shout out to Deshaun Fry with 199. Thank you so much, Deshaun. Deshaun says, hey, AV, you think Thug is going to get a bond? Well, no, I don't think that she's not going to reverse any of those prior rulings. Like they're going to be legally sound. I don't think that she's going to do that. I do think that she has a big decision to make on the mistrial. Because if that happens, Brian wants that. Brian, all these defendants want that. Because essentially, if there's a mistrial, double jeopardy could attach and you cannot retry them. So the defendants want to win. And they got a significant win with getting Glanville off. This is huge for them. Now we have to, when you get a new judge, and this is why we went through the data, guys, what is the likelihood that she is going to be friendly with some of these motions, right? So super, super interesting question and a good one, Sean. Thank you. Thank you. Thank you. You got your thinking cap on today. I love it. Shout out to Lord Bushido, the $5. Like the stream. What's up, y'all? Shout out to my girl, AB. Love y'all. I don't know why I just gave you Jamaican accent. Listen, they put an extra shot of espresso in here today. She was like, do you want 4 shots? I was like, sure. I got to stream on a little bit. So I apologize for that one. But thank you, Lord Vashida. And he's right, guys. Like, all that extra digging, like I got that report. I paid for it. It was like $150. So that's how much I'm committed to bringing you guys great content. Like, I invest in my channel like that. Like, if it's something that I know is going to be beneficial to legal education, edutainment, that is something that I'm willing to invest in. So thank you so much, Lord Vashida. And if you guys are watching this on replay, don't forget to hit the like button there too. You can do that on replay. All right, guys, I'm going to go ahead and head out of here. Thank you all so much. Let me know what you think in the comment section. If you think that she is going to grant the motion for mistrial, tell us why you think that. If you think she's going to deny the motion for mistrial, let us know what you think in the comment section. When y'all give us feedback, it helps us make better content in the future. So with that being said, I'm going to head out of here. Wait, let me catch Mahadi. Mahadi with $2. He says the 403 abuse is too compelling to ignore. 403. Oh, rules of evidence. Look at you, Mahadi. Yeah, it is hard to ignore. It is hard to ignore. And we're going to see what happens in the coming days. But thank you guys so much for the love. It's all going to be great. And I will see you guys in the next one. Stay safe out there. Have a wonderful day. And we'll see you soon. Bye.